Welcome to the Family Wealth and Ageing Financial and Legal Considerations presentation. My name is Sam Hunt and I'm joined tonight by Jennifer Dixon from Moores Legal. Why is this topic important? Well, many of us, myself included, are finding that we're becoming increasingly involved in managing the affairs of our parents as they get older. But we might actually not be aware of some of the important sort of financial and legal considerations. And in this presentation, I really hope that we can address some of those issues. So at least it's a beginning of an understanding as to what might be involved. And we can expand upon some of these issues in future presentations. Just a quick reminder that this is general information, so seek advice before making any decisions. So the agenda for this presentation is just looking at some common family challenges, and the challenges that I've selected are quite acute. So there's obviously a wide variation that you might actually see, but these ones are quite dramatic. We'll then step through some important estate planning considerations, and then really let's start building out a family wealth management plan. So common family challenges. No family is perfect. And here is a terrific example of a blended family that we're all fairly familiar with that's had considerable amounts of issues. If you look at this family in particular, there's been a death of a mother, there's been a repartnering, which has caused a bit of rift within the family. And then you've seen two brothers now that are kind of at loggerheads, and their respective spouses aren't getting along particularly well. And more recently, quite sadly, that the king has become unwell, and sort of who now is in a position to help make those important considerations. Yes, he's a king, but he's also got a family, and really, how do they want to help make decisions for him for both financial and legal considerations? One of the other sort of overarching issues with this family is that you've had a matriarch that may have stayed on too long in the job and is now handed over to an elderly son who is now become infirm. So there's a whole range of issues that potentially could have been addressed a little bit better. Yes, it's the royal family, so there's some sort of restrictions about what they can and can't do, but it sort of highlights, if we look at a typical family scenario, there's probably shades of grey for a lot of these things that a lot of us face. Another scenario is, in a medical emergency. So, we all sort of never want to receive that dreaded phone call from late at night from a parent. So let's say you get a call from your mother that your father has suffered a stroke and is now in intensive care. That's a really stressful time. And those questions that really arise at that point in time is, wow, is mum able to make these important medical decisions on behalf of dad, considering how much stress she's currently under? Is there enough money, or do we have access to cash to be able to fund some of these medical expenses while we work through what's actually going to happen? What will life potentially look like on the other side? And if you haven't thought about these issues prior, and this medical emergency is just dumped on you, it's not a great time to start thinking through what do we need to do. It's much better to try and address them ahead of time. Do you have any sort of insights here, what you've seen, Jennifer, for clients that have...
Yeah, so I guess the first question in the face of the medical emergency, or a potential question, is who has authority to actually deal with the medical practitioners. The family will typically get asked who holds in Victoria, the appointment of the substitute medical decision maker document. If people aren't clear about that, that can create some confusion. In the absence of that document, there is a statutory list of persons authorised to make decisions for someone, which may or may not suit your family. So, yeah, again, reinforcing, I guess, what Sam says is about being prepared. Certainly means that you don't have those added stresses in a time where it's already going to be pretty stressful.
The other big one that I know you've seen a lot of, Jennifer, and we have begun to see a little bit more of, is around mental capacity, and not picking on Joe Biden, but it's brought up quite a lot in the press, so it's probably sort of a point to raise that we are living a lot longer in general. And what happens in the instance where you've got a parent that appears to be or has lost that capacity to kind of make those decisions, then who can really step in to help guide them? So, from a financial and medical perspective, if they're unable to make decisions, who is the person that could potentially step in to help make those decisions? So before we probably jump into who can and can't, maybe, Jennifer, you just want to expand a little bit about how capacity is assessed. Like you might have these conversations with the parents and thinking, oh, look, what's going on? Or, it might be a spouse having the conversation with their partner around, I'm not sure that he or she is actually fully with it at the moment. How do you assess capacity?
Sure. Well, capacity is a really tricky area. But it's one that you just can't ignore. The demographic statistics tell us that over 50%, I think it is, of people over 85 or 80 have some form of cognitive impairment. The reason it's so tricky is because it's not necessarily a one-size-fits-all test. What the law prescribes is that it is decision specific. So that while someone might have capacity to do one thing, they may not have capacity to do another, which is not that helpful for someone in the family trying to navigate this. Unfortunately, that's the area we're in. The broad statement of capacity that I've put that's in the second bullet point there, is one that you find the themes recur through the various legal tests. So you'll see it talks about understanding and retention of information. So that memory concern will go to a question of capacity. More important, well, I won't say more importantly, but equally importantly is this ability to weigh up and form judgments. So that follows on from the understanding and retention of information. But capacity also means that you have to be able to form a judgment about different questions, and then be able to obviously communicate the decision in some way. I guess in practice, one of the reasons capacity is a concern is when you can see someone whose capacity is declining. Again, we know that also then exposes them to greater risk of influence or being scammed, and that goes to that diminishing ability to form appropriate judgment. So how do you actually work that out? There is a medical, usually you'd like some medical evidence if there's a concern. So there's this thing called the MMSE, mini medical assessment, which sometimes GPs use, where people get asked to, draw a clock and remember words and things like that. That is a very basic form of assessment. You tend to find when things are getting more contentious, people tend to then move to either a geriatrician or a neuropsych who can do more in-depth assessments, because you find with the MMSE, it's more about that understanding and retention of information, and less about the judgment question, whereas a geriatrician or neuropsych will put more emphasis on those elements as well.
And what do you do sort of in the instance where there's periods of lucidness and then coming out? So they may come to see you or that GP and be able to be at a fully sort of incapacity at that point in time, but when they get home, they're completely different. So how do you make the call from that point of view?
So the law tends to lean towards an assumption of capacity, and that people should have their own autonomy for as long as they can in whatever way they can, even if it's potentially not in all areas. So, it might be that someone has capacity to do basically basic sort of day-to-day things, but may no longer have capacity to remain a director of a trustee company, for example. So it's not it's very rarely an all or nothing thing. There are examples where it's very black and white that someone no longer has capacity, but more and more we see that very grey area, which does unfortunately create practical difficulties.
Yes. So if we then move on to who can actually make these decisions and sort of addressing like the powers of attorney, and maybe if you want to expand upon what's the difference between a general power of attorney and then an enduring power of attorney, both medical and financial. And if we go back to the original example with the royal family, you know, Camilla is now married to Charles as his legal wife, and he also has 2 sons from a previous marriage. In that scenario, who would actually make the medical decisions on the King's behalf?
So if they were in Victoria, because this is another unhelpful position, that in Australia we have different laws in every state. So if they were in Victoria and there was no medical treatment decision maker document in play, then the legislation would default that to Camilla. So the point of having the medical treatment decision maker document is to ensure that you've got the opportunity to appoint who it is that you want to make the decision, which might be Camilla anyway. But the other advantage of having the document is that it's clear. You're not relying on statute to dictate who's making those decisions. In Victoria, our document allows you to appoint one person at a time. So you can have one primary person nominated. You can put a backup into that, but it can only be one person, which is difficult when there's multiple kids. You can have additional backups as well, but it's only ever one person at a time in Victoria, which is not the same in all the states. So if you're going back to your royal family example, Charles may have had Camilla as his backup. You know, he may choose William. Would probably be recommended that if he's more local as well. And then he might have Harry as the third, but he can have whoever you want, really. It doesn't have to be family members.
Yes. And just the importance of kind of having those conversations with adult children, even if, say, the King was to appoint Camilla as his medical power of attorney, it's really important that both sons are aware of that. So she's, in the first instance, the person that will make these decisions, which might have some issues that need to be addressed. But look, it's better to have those discussions now than as opposed to him in a bed and she's making the decisions and the boys are completely cut out of the loop. That's
also good for the family to understand that in Victoria legally you can only appoint one at a time, that's not necessarily a favouritism or a choice that's being made by someone. They've been forced to choose one person at a time.
Yeah, and to that point, it's probably, well, I think almost better to have one person, because if you get 2 and they can't agree, then how do you actually make that decision? So I'm assuming that's why that's the case in Victoria. But as you say, Australia, different rules in every state. So, you know, if parents are living interstate, then they need a different medical power of attorney and potentially financial power of attorney. So we've addressed medical, that's to make medical treatment decisions on behalf of a person. What about financial decisions, or that the enduring power of financial attorney?
So on financial matters, and this will pick up what you were saying before, Sam, about you can do 2 different types of powers of attorney dealing with financial matters. One's a general power of attorney, where you're authorising someone to do whatever you can do, but a general power of attorney ceases in operation once you lose capacity, whereas an enduring power of attorney will continue beyond the loss of capacity. Now, in this in Victoria, it's actually, the law now is that we've got the ability to do financial decisions and what are called personal decisions. So financial is asset, personal is things like where you live, do you stay at home with a carer, that sort of thing. You can actually do both of them in the same document. But they are 2 distinct roles. So if, for example, you were going to choose different people to take care of assets, as someone, for example, someone who's deciding where you might live, you can do them in separate as well.
And that's what we typically see with clients, that if they are selecting adult children to make those decisions, one will be the medical power of attorney and the other will be the financial power of attorney. Whether it's just a decision to split roles or whether that's skill sets, I mean, that's obviously an individual decision to make.
I tend to think in the financial space, there's some merit in looking at mirroring the executors in the will, which might be each other for the spouse and then a backup of potentially multiple people. It's quite a different role to the medical power of attorney, and obviously has flow-on implications in terms of the will too. So
yes. One of the really important aspects, it's great to have these documents, but you've actually got to do something with them. So, we recommend that you have a certified copy as well as the original in a place that people are aware of where it's at. So if you do need to access it, but, if I think from the perspective of an advisor, where we've got a client that's potentially losing or has lost capacity, we need to be very clear as to who we're taking instruction from. So whilst that case of may be lucid during specific times or not, then who are we actually taking instruction from? You need to load these powers of attorney or enduring powers of attorney up with financial institutions. So if you want to speak to, say, the bank or your super fund on behalf of that person, then they need certified copies. Again, if it's things like even boring utilities, they won't speak to you unless you've got these things in place. So, trying to fix phone bills, etc. Like it's really important to have that document. And then the enduring power of attorney for medical is just ensuring you've got that certified copy or the original that you can bring it to the various places, whether it's hospitals, specialists, etc., to make those decisions on behalf of that person. The next common challenge, which we sadly all face, there's only two certainties in life: death and taxes. One you can't avoid, and one you certainly want to try and minimise or reduce as much as possible. So, giving consideration as to how your assets are to be distributed upon your death is a really important consideration, and needs to be documented in a will. And some of the issues which Jennifer will expand upon is that during your lifetime, if any children have received, say, unequal financial assistance, how's it actually going to be addressed in your will? Because if you don't have a conversation or a discussion with the children now, and it's not necessarily addressed in the will, that is definitely a potential issue when you're not around. If you've repartnered, so in the case of the royal family, the king is now married to Camilla, how is his assets going to be actually addressed for his adult children? What are the implications there? So there's a whole range of things that kind of come into place, but I think being as transparent as you can in terms of the distribution of your assets is a really important thing, but it also raises quite a few issues that, Jennifer, I think you might like to touch on. If you are too transparent, what are some of the issues that you've seen in the past?
I guess my view is transparency is good from the point of view of having everyone in the family understand what's going on, so that when someone passes away, there's not sort of a shock element to what is taking place. Where immediate transparency can cause some issues is where there's a chance that the person making the will might change their mind, because sometimes having those conversations set up, rightly or wrongly, set up expectations. But it's that balancing act, and I guess family specific as to whether that's appropriate, particularly for clients that have structures or some more complexity though. Having some transparency around how they operate, what whoever's going to inherit might need to be thinking about, that's certainly definitely a valid position to take. And what you want to avoid is, I guess, side conversations that aren't recorded anywhere. And even in my own family, as recently as last week, this is a bit silly, but one of my brothers told me on the phone that my dad had said he could have his coin collection. And I know what's in my parents' wills, and it doesn't say that. So we'll have to deal with that at some point. Not that I don't think it'll be that controversial, but but it can be much bigger than that. So those side conversations need to be reflected properly.
Absolutely. Or if they're not necessarily documented in a will, that they are documented, that all parties are aware that this was the intention, preferably in the will. We won't spend too much time necessarily here, but capacity is also important when you are drafting a will, hence why get it done early before capacity is an issue.
Yeah, so there is a legal test for capacity to make a will, which is basically that the person needs to understand broadly what their assets are and what a will is doing, and equally be able to understand who they should be considering and not be suffering from delusions. That's the case law test.
Yes.
We see in practice is that as lawyers we're obliged to make a legal assessment of the capacity applying that test, which is why a lawyer doing their job properly will ask various questions around that. You'll often find, though, as well, that the other reason a will can be knocked out is if there's a allegation of undue influence. So even though with the best of intentions, families might want people in the room that are not the will maker, that can create issues down the track if there is a party who might suggest that the sibling that was in the room was having some bearing or influence on what mum and dad might have been deciding.
Mm-hmm. This slide sort of just talks to, like, we often use jargon, and not necessarily that calling an estate plan is jargon, but I think it's probably important to kind of highlight that when we're talking about an estate plan, there's three broadly key elements. One is the will, or how your assets are going to be distributed upon your death. Then there's the non-estate assets and or documents, which really is anything that's not covered by your will, which might be a surprise to some people that superannuation is really a non-estate asset. Those funds are held in trust for you, but they're actually not in your name. So you need to let the super fund know where you wish those proceeds to be paid out upon your death. And for other non-estate entities, such as companies or trusts, there really needs to be a statement of wishes or instruction as to how those assets are to be dealt with, beyond your life. So there's three key elements: the will, the non-estate documents, and then, as we've touched on before, around those enduring powers of attorney. That's what we would look at when we talk about an estate plan. So making sure you've got all those areas covered off.
Yeah, I think it's not always common knowledge that there are assets and interests that people have that aren't covered by the will. So as Sam mentioned, super can fall into that category, assets within family trusts, and sometimes companies you can't deal with directly in the will, but also jointly held assets, so property as joint tenants. So sometimes in that blended family scenario, Charles might want to leave Camilla a life interest in his half interest of a property. If it's owned as joint tenants, it's going to go 100% to her. It won't matter what the will says. So all of that ownership and recognising what the will does and doesn't do is really important.
I'll talk to some of the things that you can do now. I mean, I've put here prior to incapacity, but it doesn't necessarily need to mean that there's going to be a position where there is incapacity. It's just like, my own situation with my own family, working with my father. I've got a brother and his dad. My mother passed away some years ago. What we've elected to do is actually to become a little bit more involved in the discussion. So my brother and I are now directors of the trustee company for the family trust, along with Dad, so we can help him start making decisions. And we've also become members of his self-managed super fund. So it's really just getting involved early on so we can help make decisions. One of the important things with, say, a self-managed super fund is that it's absolutely critical that there is a enduring power of attorney financial in place, because if that member, so let's say in this instance Dad became completely incapacitated, there's actually no one that can operate the fund on his behalf or his balance on behalf unless that document's in place. So it's really critical that you've got it, and it's really critical that it's sort of noted at least within 6 months of that loss of capacity.
Yeah, I think that the case for involving children in these roles tends to become a bigger question when there's only one surviving parent. And even then, it is, I think, a case-by-case basis. You need to be very careful. And in a family where everybody's getting along, that's fine. In a more fractious position, I know it's not the case in your family, Sam, but there could be a position where you and your brother gang up on your dad. So people just need to go into those arrangements with their eyes open and look at what other protection mechanisms might be appropriate. But there certainly is a case in some scenarios for having that assistance formalised in those roles.
So I'd now step on to like a family wealth management plan. Like we've touched on 4 acute areas, whether it's sort of family dysfunction at whatever level, medical emergency capacity or death. Like, there'll be shades of grey for everyone in terms of those issues. But what we would strongly encourage is to just start having a conversation, whether it's between spouses, between siblings and adult children, about, hey, look, what's to happen both now and into the future with our assets? How do we want to try and tackle some of these issues? If there's sort of any underlying family issues, maybe it's an opportunity to try and address them now. Easier said than done, but where they can't be addressed with the people in the room, do you try and get an independent advisor who's quite skilled at trying to navigate some of those issues? So, upon incapacity or demise, that they don't fester and blow up the family beyond you being around. One of the other things to consider is whether you set up a family constitution, which sounds like a 20-page, very formal document. No, that's not the intention, but it's really just a kind of a set of guiding principles to help people make decisions. So one of the priorities as a family group that you might have is that you wish to support future generations in education. So if that's the case, what decisions do you need to make with the current mix of assets that you have, or income coming through, that will actually help that value or that principle be achieved? Have you seen much around family constitutions, Jennifer? Are people sort of adopting these more commonly now?
They tend to be, they're given a variety of names, and sometimes they're done really as not necessarily a consensus process. Some it's more just an edict that's documented that this is what the expectation is, or it can be that sort of whole family involved process. You tend to find that the whole family getting involved is usually where we've either got some additional complexity in terms of structure, or the numbers are large, or whatever. There's usually a reason that's driving that.
Yep. The next step, once you've started the process, is really to try and locate and review these documents. If they don't exist, get them in place. Or if they do exist, are they still appropriate? Like the will might have been drafted when parents were first married, or the parents' will might be up to date, but lo and behold, the adult children don't have a will. Well, terrific. So if the parents were to pass away and those assets were then to be transferred to the next gen, how are they going to be treated if that generation has unfortunately passed away? Tracking down, property titles, getting an understanding where appropriate of the complete financial picture. The other piece is really just trying to identify who the incumbent accountant, solicitor and financial advisor, so at least you know who you're dealing with and are they still fit for purpose. So just doing a full review about where is everything and is it still appropriate.
Yeah, that's one of the things that really causes a lot of headaches if it's not done prior to death, because you find that people then are coming in who don't have the background knowledge trying to locate things. It creates a lot of headaches.
Major headaches. The next step that we would encourage is just that ongoing review and management. And if you can hold regular meetings with family members with a specific purpose to address that family wealth management plan, and it doesn't have to be week in, week out. It might be once a year or twice a year that you might just want to touch on any issues, making sure that if there's been any changes to family circumstances, there might have been the children have now divorced, so okay, the wills now need to be changed to reflect that. One of the things that we would really encourage is that minutes are taken at those meetings. To touch on your earlier point, Jen, around the coin discussion, that if everyone's happy with that scenario, record it, circulate it to all parties. So hey, look, it's not a shock at the end of the day when the parents are no longer here and the brother gets the coins. So just everyone's aware of what decisions have been made, and it's a document that you can refer back to about, okay, what did we discuss and what did we agree upon. The little meeting agenda that I've put here is actually the one that I use with Dad and my brother. So we try and catch up every 6 months around sort of making financial decisions. Has there been any kind of potential changes to scenarios, to like what needs to be done where? Just look at the roles, whether you're medical, whether you're financial power of attorney, is that still appropriate? And if there needs to be any changes from an estate planning perspective, it's at least to say, hey, look, we know where the will is. Has anything changed? No. So it's just really kind of getting into that process that you can address those things. And it's terrific because it takes it away from having the discussion at Christmas Day or Boxing Day about, hey, is everything in place? It's a formal meeting that we have. We tick it off, it's done, and we can then get on with life and talk about more important things like football and wine. So the actions and next steps out of this presentation, the first really important thing is to address your estate plan. So looking at those 3 key elements around the will, the non-estate assets, and the enduring powers of attorney. Are they in place? If they're not, it's really important that you do get them in place. If they're in place, do they need to be reviewed? And then start that formal process of, okay, let's setting up a structure or a cadence around that family wealth management plan where you're at the first point of call addressing those 4 acute issues if they're relevant to you. Particularly the most important ones will be medical, potential capacity, and death. Hopefully there's not dysfunction, but if there is, there are the things that can be done to address those issues, and where appropriate, seek financial and legal advice and assistance so you can navigate that process. I'll just finish here with a slide with our contact details, which I'm sure many of you have, but please feel free to reach out to me or to Jennifer if you've got any further questions or you'd like any advice in these areas. So I'll wrap up the presentation here. Thank you for attending today, and certainly reach out if there's anything you'd like us to address.